Plaintiff. The person or entity who initiates a civil lawsuit by filing a complaint against another party, claiming to have been harmed or wronged in some way. Defendant. The person or entity being sued in a civil case, or the person accused of a crime in a criminal case, who must respond to the claims or charges brought against them. Petitioner. The party who files a petition asking a court to take a specific action, commonly used in appellate cases, family law matters, and administrative proceedings. Respondent. The party who responds to a petition filed by a petitioner, essentially the opposing side in cases where petition-based language is used instead of plaintiff/defendant. Appellant. The party who lost at the trial court level and is appealing the decision to a higher court, arguing that a legal error was made below. Appellee. The party who won at the trial court level and must now defend that victory against the appellant's challenge in a higher court. Counsel. The attorney or lawyer representing a party in a legal proceeding, used as both a title and a general term for legal representation. Co-counsel. An additional attorney who works alongside the lead attorney on the same case, often brought in for specialized expertise or to share the workload on complex matters. Amicus curiae. Latin for friend of the court. A person or organization that is not a party to the case but submits a brief offering relevant information or perspective to assist the court in its decision. Guardian ad litem. A court-appointed representative, often an attorney or trained advocate, assigned to protect the legal interests of a minor or incapacitated person who cannot represent themselves. Intervenor. A third party who was not originally part of a lawsuit but is permitted by the court to join the proceedings because they have a direct interest in the outcome. Third party. A person or entity outside of the original plaintiff-defendant relationship who may be brought into a case because they bear some responsibility for the dispute or have relevant interests. Witness. Any person called to testify under oath in a legal proceeding, providing first-hand knowledge or observations relevant to the facts of the case. Expert witness. A witness with specialized knowledge, training, education, or experience in a particular field who is permitted to offer opinions, not just facts, to help the court understand complex technical or scientific matters. Lay witness. An ordinary witness without specialized expertise who testifies only about what they personally saw, heard, or experienced, and is generally not permitted to offer opinions. Prosecutor. The government attorney responsible for presenting the state's case against a criminal defendant with the burden of proving guilt beyond a reasonable doubt. Defense attorney. The lawyer who represents the defendant in a criminal case, tasked with challenging the prosecution's evidence and protecting the defendant's constitutional rights. Public defender. A government-employed attorney appointed to represent criminal defendants who cannot afford to hire private counsel, as guaranteed by the Sixth Amendment. Pro se. A Latin term meaning for oneself, referring to a party who represents themselves in court without the assistance of an attorney. Judge. The neutral judicial officer who presides over court proceedings, rules on legal questions, ensures proper procedure is followed, and in bench trials also decides the outcome of the case. Magistrate. A lower-level judicial officer who handles preliminary matters such as bail hearings, initial appearances, and minor cases, often reporting to a higher court judge. Clerk of court. The court official responsible for maintaining court records, managing the docket, swearing in witnesses, and handling administrative functions of the court. Bailiff. The court officer responsible for maintaining order in the courtroom, escorting the jury, and ensuring the physical security of the proceedings. The bar. The physical railing separating the public gallery from the area where the judge and attorneys sit. Also refers to the legal profession itself. Court reporter. The official who creates a verbatim written transcript of everything said during court proceedings, producing the official record that can be used for appeals. Sustain. The judge's ruling agreeing with an objection raised by an attorney, meaning the objection is valid and the question or evidence will be disallowed. Overrule. The judge's ruling disagreeing with an objection raised by an attorney, meaning the objection is denied and the question or evidence is permitted to proceed. Proffer. An offer of evidence made for the record, often used when a judge has sustained an objection, to show what the evidence would have been if allowed. Sidebar. A private conversation between the judge and the attorneys conducted at the side of the bench, out of the jury's earshot, typically to discuss a legal issue without influencing the jury. Bench trial. A trial in which the judge alone, with no jury, hears the evidence and decides both the facts and the law, rendering the final verdict. Chambers. The judge's private office located outside the courtroom, where confidential meetings, informal hearings, and certain legal discussions may take place. Docket. The official court calendar or schedule listing all cases pending before the court, as well as the log of all filings and actions taken in a particular case. Continuance. A postponement of a scheduled court proceeding to a later date, granted by the judge at the request of one or both parties, or on the judge's own initiative. Recusal. The voluntary or mandatory withdrawal of a judge from a case due to a conflict of interest, personal bias, prior involvement, or any circumstance that could compromise impartiality. Judicial notice. A judge's formal acceptance of a well-known or easily verifiable fact as true without requiring the parties to present formal evidence proving it, for example, that a particular date fell on a Tuesday. Jury instruction. The judge's formal directions given to the jury before deliberation, explaining the applicable law, the legal standards they must apply, and how they should evaluate the evidence. Voir dire. The process of questioning potential jurors to determine their suitability and uncover any biases before they are selected for the jury. Charging the jury. The formal process by which the judge delivers final instructions to the jury at the close of trial, charging them with their duty and the legal framework for reaching a verdict. Sequestration. The isolation of jurors from the public and media during a high-profile trial to prevent outside influence on their deliberations, typically involving housing them in a controlled environment. Contempt of court. A ruling that a person has willfully disobeyed or disrespected the court's authority, either by defying a court order or by disruptive behavior in the courtroom, punishable by fines or imprisonment. Gavel. The small mallet used by a judge to signal the opening or closing of court, call for order, or punctuate a ruling, symbolic of judicial authority.